Welcome to this free immigration help channel. Today is June 19, 2023, and we're getting into the volume 121 of me answering your immigration related questions. As you can see, I have all your comments and questions pulled up in front of me. As always, before beginning this video, I'm going to mention I am not an immigration attorney. This is not legal advice. All the information provided in this video on this channel are directly from official government sources like USCIS and of course the Department of State with their visa bulletin. So let's start with the very first question comment from Rajan Devkuda. Rajan says, does anyone know if F2A will be current in October 2023? So Rajan, what I'm gonna need to do, what I'm gonna need the information in order to give you some rough estimates on when your particular priority date is going to be current. It's the priority date itself. I know that it's F2A, and then also the chargeability area, because depending on the chargeability area, it's going to be different, because there's 4 separate chargeability areas for China, Mexico, Philippines, and India. That's 4 countries that have a separate chargeability areas. All the other countries are in all chargeability. But let's take a look at the visa bulletin for July 2023, and I'll tell you approximately when the F2A in general is going to be current. And it's very rough estimates, keep it in mind. So we're going to take a look at the graph A, which is the final action date, and that's basically when the immigrant visa is going to be available. So as of July 2023, if you look at the F2A category, we see the date 8th September 2020. And basically that's the date, that's the priority date. So people with priority date in September 2020 and earlier, as of right now in July 2023, their immigrant visas are finally becoming available because their priority dates are becoming current. As of right now, June, July 2023. That's September 2020. So please let me know if you want a little bit more still very rough estimates, but a little better estimates, very personalized for you. Let me know your priority date, your preference category I already know, but put it again please, and then the chargeability area, because depending on the chargeability area, it might be different as well. As you can see, for China and India, it's the same as all chargeability area, but for Mexico and Philippines, it's actually a little bit, well, for Philippines it's the same, but for Mexico it's a little bit different. It's looks like 2 extra years to wait for the availability of the immigrant visa. So I'm gonna post this response here. And if you want, like I said, a little bit more information, and that goes for everyone who's watching these videos, if you need a rough estimate, 3 things that I need: your priority date, your chargeability area, and the preference category. And when you are responding to my follow-up request, basically, make sure not to respond to my comment within your comment, because YouTube does not send me those notifications. So please submit it as a separate comment. Alrighty, moving further to Mbenga Mirabeu 4472. So Mbenga says, hello, thanks for the good content. I'm on a B1 visa expiring in July 12, 2023, and I want to apply for asylum and B1 extension. Just want to know if it's possible, and what is your advice on my choice of adjustment of status? Thanks. Okay, so Mbenga, applying for asylum and B1 extension are completely 2 separate paths, right? And none of them are actually the adjustment of status, because adjustment of status is switching from non-resident to a resident, to becoming a permanent resident. That's the adjustment status. And neither of those, technically, yes, asylum does open up, the passage to becoming a permanent resident, but still, the asylum status itself is not a permanent resident. It does not guarantee you permanent residence either. Now, between the two, between the asylum and B1 extension, B1 is just a visitor tourist visa, basically, non-immigrant. Asylum, when you're applying for asylum, you are telling US government that you are being persecuted in the country where you came from, and you cannot go back there, because if you do, you're risking severe threat to your safety, to your well-being, to your life, basically. So if that's what you experience, then yes, absolutely, you definitely need to apply for asylum, and you shouldn't even consider the B1 extension. But if that's not the case, then I would recommend for everyone, don't apply for asylum if you are just trying to extend your stay in the United States of America, or if you think that it's an opportunity to immigrate to the United States. I would not recommend applying for asylum. Why? Because it's a very, very complicated process. There's a lot of stuff that is involved, and especially now, it became more difficult for people that are not really persecuted in their home countries and are claiming asylum just because they are trying to immigrate to the United States. They're not really persecuted in their country, but they just want to stay and live here in the United States. It became harder to do that if the case is not genuine, if it's not real, because as of recently, recently it's probably a year, maybe year and a half, maybe a little bit longer, when you're applying for asylum, these fresh applications, they are scheduled the interview very quickly. They're scheduled within 30 days. You're scheduled the asylum interview. And if your asylum case is not strong enough and it is denied, you do not have a right to appeal it to the immigration court like you used to before. Some of the asylum applications that are denied can go to court if you have been waiting, if you are in an older group, that you have filed your asylum application a long time ago and you have been waiting for your interview for a while. Those asylum applications still have the right to appeal the decision and go to immigration court. But the newer asylum applications, they no longer have that ability to appeal, which became a problem for the people that are, claiming asylum not because of genuine reasons, if that makes sense. Because if you don't have a strong case, if you don't have the evidence to corroborate your case that you really are being persecuted in the country where you're, claiming the asylum from, not to go back to the country where you came from, then, if you're denied the asylum, you are immediately placed in the removal proceedings. So I would not recommend playing with that. It's a very serious process. But as far as the B1 extension goes, really all you need to do is file the form I-539, application to extend or change status, and that is a very, very straightforward process, very simple. You can file the application online if you're filing it for yourself. So between the two, if you really just want to stay longer in the United States of America, B1 extension, absolutely go for it. But if you, of course, have a serious reason not to go back to the country where you came from, there's danger for your life, you're being persecuted there, then yes, absolutely, I would not even tell you to consider B1. Go ahead, apply for the asylum. If you're applying for asylum, you need the form I-589, which is, as of recently, you can file that application online as well. For both of the forms, I do have the video on how to fill them out on this channel, so if you need more information, you can definitely do your research. Alrighty, let me put this, and we're gonna move on to the next question from Revit XO Store. What if my parents are still living outside of the United States? When can I file I-485 form? Do I need to wait after my I-130 form approval first? Revit, great question. Thank you for asking. So yes, absolutely, you do need to wait for the approval of I-130. Once your I-130 is approved, it is transferred to the NVC for further processing, where you documentarily qualify, with your parents, where your parents, beneficiaries, submit all the documents to become documentarily qualified. Once they do, I'm assuming you have filed, petition for your parents. So I'm assuming that you are a U.S. citizen and your parents are in immediate relative category, which is great news, because once the I-130 petition is approved, the immigrant visa is already available. So you don't have to deal with the visa bulletin and wait for the backlog for their priority dates to become current. There is none of that, which is fantastic news. Once they are documentarily qualified with NVC, and I would recommend actually a video on this channel. It's called Documentarily Qualified, and I would recommend it to everyone who is not documentarily qualified yet and who will be dealing with that process. It's called documentarily qualified. What does it mean? And in that video, I show a real NVC portal that was already documentarily qualified, so you can see all of the documents that need to be submitted, all of the fees that need to be paid, all of the applications that need to be filled out. But the good news is that you don't need to worry about I-485 form at all. Once everything is paid through the NVC, once your parents get the immigrant visa, once they come in with that immigrant visa into the United States, that immigrant visa automatically converts into a temporary permanent resident card. And then if all the fees were paid through the NVC, within like 90 days, which is most of the times less than that, but within 90 days of your parents entering the United States, they will receive their permanent residence cards. So you don't even need to worry about I-485 if they are doing it from the outside. The only time, and that really is for just for informational purposes for everyone else who's watching this video, the only time where you need to worry about I-485 is when the beneficiary is actually in the United States of America, and you don't need to be, and they don't need to be going through US Embassy. They are going through the field office here in the United States. That's when you file the I-485 together with I-130. Okay, so let me post this response right here, and we're gonna move on to the next question from OG Babao. Your reply is highly appreciated. I am F1 category, sons and daughters over 21 of US citizens from Philippines. My priority date is July 2013, and I am documentarily qualified March 1st, 2022. When do you think my interview will be? Alrighty, let's take a look at the visa bulletin. So Philippines, they have a separate chargeability area. Priority date we know is July 2013. So let's take a look. F1, we're gonna look at the graph A because you're already documentarily qualified. So F1, Philippines, looks like as of right now, people who are getting their immigrant visas, whose immigrant visas are becoming available, are those with a priority date back in March 2012. And you are in July 2013. So you are looking roughly at another year and, what is it, between March and July? March, July, so you are forward, not back, so it's going to be March, April, May, June, July. So roughly a year and 4 months you're looking at before the availability of the immigrant visa. Again, keep in mind, there is some administrative processing with, scheduling the interview, so far, so forth. Depending on, how busy the U.S. Embassy in Philippines is, it might take another 3-4 months before the interview is scheduled. But roughly another year and 4 months before your priority date becomes current. And then after it is current, then the interview is scheduled. So I would say, we are in June 2023. I would say by the end of 2024, most likely you're gonna have your interview for your immigrant visa. But great news that you're already documentarily qualified, huge milestone. So for the most part now, it's really just a wait game. All right, let's move on to the next question, comment from Sunrise GP3YM. I pray to God to open the doors for all families and reunions with their children. I feel for all because my mom applied for my brother since February 2017 and my sister applied before in January 2012. My mom every day praying to see her son. I'm happy because the case moved and maybe the website will open soon and pay the fee and submit the document. I subscribe your channel and I hope you will help people who need to understand what's going on. I appreciate and God bless you. Sunrise, thank you very much for your very, very kind comment, and I definitely do share, and I pray that, indeed the things will change for the families, because, one of the most important things that we have is, after faith, of course, is our family. And it's really sad to see the, U.S. government not being very, I wouldn't say not understanding, because I'm sure everyone in the government, in the Congress, understands what they're doing, but the problem is that they're choosing something that is more beneficial, something more that brings more money and brings more attention to them, brings more power, because we're dealing with politicians, and politicians, they care about profit, obviously, they care about their careers, they care about being reelected, unfortunately, and that's just the way it is. That's just politics. And whenever it comes to immigration, the field of immigration, family reunification, it does not really bring any profit. Family reunification does not really bring any attention. Mostly it's the stuff that we hear about on the news, and whenever it comes to stuff on the news, it's really just the border, the refugee crisis, whatever, border crisis, whatever it is they talk about on the news, which are the issues as well. But a U.S. citizen waiting for their son or daughter to come and be here together with them for 9 years, and that's for all chargeability area. If you're from Mexico and if you're doing legally, then you're waiting, same F1 category, you're waiting for since April 2001. So you're waiting 22 years right now. If you're a Mexican national, right? You came from Mexico and you became a naturalized U.S. citizen, and now you're petitioning for your daughter, let's say, who is 22 years old, right? To come here to the United States of America from Mexico to be together with her father, with you, right? If you file it today, as of right now, roughly, looking at the visa bulletin right here, Mexico, you're going to be waiting for roughly 22 years. And most likely more, because the backlog keeps on growing. 22 years. So your 22-year-old daughter, you're roughly going to see her when she's going to be like 44, 45. Think about this. That's if you're doing it legally. So, of course, when you have a situation like this doing legally, it's just, it makes no sense to do it legally and just, you rather just go and, jump over the border. And there you go. This is where the crisis starts, right? This is where the border crisis starts. So it's really, if you want to get rid of it, make it easier for people who are doing things legally to reunify with their families, right? So problem is it's all attention on the news. When you talk about border, when you talk about all that stuff, you get more attention on the news, right? So everybody talks about the border, but nobody talks about the actual, families who did things legally, who are doing things legally, and who are waiting for years and years and years, and paying the fees and going through background checks and going through medical examinations to see their family members. It's really sad, but I pray that it's going to change. I really pray it's going to change. Hopefully, we'll see. Okay, moving further to Mathusud Hanaka Daru. Okay, 5892. Thank you, sir. You are sharing very useful information on immigration. My question: my sister was applied for me and my younger sister F4 green card October 2011. Okay, our case was approved in April 2020. Please let me know, sir, still how long do I have to wait? And also my son, age 21 years, reaching 2025. Oh, I see. This is the situation, sir. Please help me. Okay, let's take a look. So F4, you didn't tell me your chargeability area, so we're going to look at all chargeability area. So let's see. So your sister applied for you in October 2011, and it's F4 category, which is forced preference category, which takes the longest, unfortunately, for siblings of U.S. citizens. So we're going to take a look at what is going on right now at F4. Right now we have the priority date of April 2007, the priority dates of before or on who filed on April 2007 are, as of right now, June 2023, are getting their immigrant visas. And your priority date is in October 2011. So you are roughly looking at another 4 years, roughly, before the availability of the immigrant visa. So unfortunately, looks like by the time you get your immigrant visa, your son is going to be over 21 already. So my recommendation for that would be to find a way for your son to get a non-immigrant visa for now, so that he can travel with you to the United States on a non-immigrant visa first. And then once you come into the United States, obviously you will already have your permanent resident. As soon as you enter the United States, you will have your permanent residence. You can file a petition, another petition, I-130 petition, for your son to start the family reunification with your son. It's very, and again, for everyone who's watching this video, you can see how dumb the system is again, because it's a non-stop cycle. Person here has been waiting already for 12 years now, and will be waiting for some more for another 4 years roughly to get their immigrant visa. And once they enter the country, they now have to start the same process all over again for their son, because their son is over 21 years old. Because if your child is under 21, when you get the immigrant visa, then they can travel with you as a derivative beneficiary because they're under 21. But unfortunately, as soon as they turn 21, that's it. Now they're in a different category, in a family preference category F1, or if they're unmarried, which now takes another, roughly for all chargeability, 9 years. It's ridiculous. The system is ridiculous. It's a horrible system. It's completely broken, and not enough people know how broken the system is. And I'm sorry to kind of share not very good news, but that's just the way it is, and one of the reasons why I started this channel is to bring the awareness to some people that do not know how bad the system is, how unfair it is set up towards people who are doing everything legally, who are paying the fees, who are going through medical examination, who are going through background checks. They don't have no criminal backgrounds. They're living in the United States legally, paying the taxes, doing everything the right way, sponsoring you're sponsoring. You have to understand, when you're petitioning for your family member from outside of the United States, you are sponsoring that family member, which means that once they come into the United States, they cannot rely on the government at all for nothing. There is no public benefits, no food stamp, no Medicaid, no nothing. You are the sponsor. The petitioner is the sponsor for the family member that they bring into the country, which takes the responsibility away completely from the American taxpayer. All right? So when you're bringing immigrants this way through the family reunification, you're doing better for the country, because these people can come in, and immediately as they come in, they already have the legal right to work in the United States of America. They don't rely on American taxpayer. They only give to the country, to the economy. They're only benefit to the economy. And yet we make them jump through these hoops and make them wait for these years and years and years. It's a terrible system. Okay, moving further, and sorry, I'm getting, but that's the reality of things. If I can't say it any other way. This is just the way it is, and it's not very good, unfortunately. Okay, next question coming from Vali DH1587. USCIS says California Center take a bit longer processing time for F3, like 115 months, but my petition has been lasted 15 years as I'm waiting for my interview. It was filled and submitted by a citizen back in end of December 2008. I'm also documentarily qualified. Why it takes longer time in California Center while in other states it doesn't take that much time? How long more should I wait? My children are now above 21. Sorry you're dealing with this. Here's the thing. Whenever it comes to the USCIS service centers, really whenever it comes to family reunification, the only thing they process is the initial I-130 and basically establishing the validity of the I-130. Once it is approved, and it really doesn't matter how long it takes in the service center, if it takes in California service center 115 months, and then in Texas service center it takes 60 months. It seems like, yes, Texas is processing stuff way faster, but at the end of the day, you're still waiting on the Department of State on the visa bulletin until your priority date becomes current. And that's really why such a huge difference between service centers. Some of the service centers, they take a little bit longer to review the I-130 because there's still a long time to wait for the priority date to become current. Some of the service centers, they like to process it quicker and then transfer it to the NVC, and then it's just sitting at NVC. It doesn't really matter which service center and how long it takes. At the end of the day, you will be waiting based on the priority date for the availability of the immigrant visa. So let's take a look at the visa bulletin. We know it's F3. We know you have your priority date in December 2008. So let's take a look what we see right now. And looks like F3 is in December 2008 right now. So you're already documentarily qualified. So your visa, the availability of your immigrant visa should be literally like right now around the corner, somewhere around the corner, because that's the priority dates that are becoming current right now are in December 2008, and your priority date is in December 2008. So I would give it another couple months. If there is no movement on the visa bulletin at all for the F3, I would recommend submitting a public inquiry form with the NVC, and I'll show you how to do that. It's a very straightforward process. Once your immigrant visa becomes available, you're probably looking at another 3-4 months before the interview is scheduled. It does take a little bit of time for administrative processing and the scheduling, depending on how busy the U.S. Embassy is in the country where you are immigrating from. But you've done pretty much all of your waiting already. It's literally around the corner. So the only thing I can say is, congratulations on your patience. So what I'm gonna do is I'm gonna post this right here, and I'm gonna find the link for the public inquiry form, and I'll show everyone how to find the public inquiry form if your priority date is current, right? And nothing is happening. I would recommend submitting a public inquiry form and asking for a follow-up from the NVC. So the way you do it is from this website right here. You can open the link in the description below for July 2023 Visa Bulletin. You will have this page in front of you. From this page, you will click on Contact Us right here at the very top. I'm going to open it in New tab. It takes a while to load. Today, we're going to scroll down a little bit. We're going to click on US Visas Contacts right here. And then we'll scroll down some more. And on the first row of this table, you will see Email Public Inquiry Form. So we're going to click on this. And then you will see Online Immigrant Visa Inquiries. Only Public Inquiry Form. So click on that. And you will have your Public Inquiry Form in front of you. Here it is. You will put your NVC case number right here. Beneficiary's full name. Beneficiary's date of birth, petitioner's full name, who you are, beneficiary or the petitioner, your email address, and then in the inquiry itself, you will just type in, a little bit of information about yourself, your name, date of birth, your case number, just the same information that you put in already, and explain the situation. Say, hey, according to the July 2023 Visa Bulletin, my priority date is current. My immigrant visa should already be available. So I wanted to follow up and see if it actually is available and if my interview is going to be scheduled anytime soon. And that's really it. They are, for the most part, pretty quick on their response to these inquiries. And unfortunately, most of the times, the response is very boilerplate. The reason why you're doing the response is if there is nothing happening for the next couple months and you need to reach out for more help, whether you're seeking for help from an attorney, whether you're seeking for help from an elected official, you have already written electronic form documentation saying that you try to reach out to the government agency directly, you try to resolve the problem with them directly, and it was to no avail. But like I said, you're almost there. You are almost there anytime now. And congratulations on doing most of the waiting. Okay, let's move on to the next question from Joanne Kalumbis. I'm going to copy this right here. Good day, sir. I'm from Philippines, married to American national, and we're applying for I-130, submitted last March 30 of 2022, and our status now is actively reviewing as of January 13 of 2023. Our concern with my husband is that until now we don't receive any new update of our application. Another thing is, if there is a new update of USCIS, I believe the statement status in the website will change. It will not be actively reviewing anymore. I hope I can have some answers on this concern. Yes, Joanne, so that is correct. Once your case is approved by USCIS, and it is only a first stage on the family reunification path, basically. Once your case is approved by USCIS, you will receive a form 797, and on the website, on USCIS website, it will say that your petition has been, your case has been closed with USCIS. But once it is approved, it will be transferred to the NVC for further processing, where you will have to become documentarily qualified. Once you are documentarily qualified, it really depends on which category you're in. You said he's an American national. If he's a permanent resident, then you will be in F2A category, which you will have to do some waiting because there is some backlog for F2A family preference category. If he is a US citizen, then you will be in immediate relative category, and in that case, you don't need to do any waiting for the most part. It's just administrative stuff that you will need to be waiting for a few months. But the immigrant visa is immediately available once USCIS approves the case. You will still have to become documentarily qualified with NVC. You will still have to go through the interview with US Embassy. But the point is, you don't have to wait for the backlog. You don't have to wait for the priority date to become current. So if you want, Joanne, let me know exactly if your spouse is an American citizen or if he is a permanent resident, and I will be able to give you a little bit more information on your concern. All right, moving further, probably last question for today from Sagar Patel 2889. Sagar, thank you very much for being publicly subscribed. This is what this icon means right here. I really appreciate that. So Sagar says, on official USCIS site, it will be written that we can opt out from F1 to F2B and stay in F2B. But as I see, when petitioner become US citizen, it not get convert automatically from F2B to F1. Correct. If I send naturalization certificate, then only they convert F2B to F1. Yes, that is correct. So can you brief this process and let me know, even if I convert my category from F2B to F1, there will be an option to opt out in future and stay to F2B again. Sagar, great question. Thank you for asking. So I'm going to start with your very last concern. No, you cannot go back from F2B, from F1 to F2B. Yes, you can switch from F2B to F1, but you cannot switch from F1 back to F2B. It's impossible. Now, how the process works, it depends on which stage of the process your case is in. If your case is still with USCIS, then you need to reach out to USCIS and inform them that the petitioner became a US citizen. And in that case, they will ask for a naturalization certificate, you send it to them, and they update the category from F2B to F1. If your case is already with NVC, then the same thing you do, you reach out to NVC now, not USCIS, but NVC, and tell them that, hey, petitioner became US citizen. They ask you for the same thing, for a naturalization certificate, you provide it, and then they upgrade the category from F2B to F1. But you cannot switch from F1 back to F2B, because once they switched it to F1, that's it. The petitioner is now a naturalized US citizen. There is no option to switch back to F2B. So keep that in mind before switching, because as of right now, it is better to stay in the F2B category. It doesn't guarantee that, with the next issue of the visa bulletin, things not going to change and F1 is not going to become better than F2B, but it is a gamble between the two, because they go like this, very close. It's most of the time is a gamble. So my recommendation is, don't rush with switching right now. Give it another time, give it closer to the availability of the immigrant visa, and stay on top of the new issues of the visa bulletins, because the closer you are, the more updates you see in the visa bulletin, the easier it is to make that decision. But thank you for the question. It was an excellent question. And thank you everyone for asking your questions. If you have any follow-up questions, don't hesitate to ask them. The more questions you have, the more blessing it is for me to be able to provide some information, and hopefully this information is, will be helpful to someone who's watching these videos. So again, thank you very much for your time. God bless, and I'll see you all in the next video.